The defense team led by Professor Tom Ojenda applying to have all the accused persons admitted to bond or bail. In the DPP's response, through Mr. Alexander Muteti, assisted by Mr. Vincent Monda, the court was informed, though the DPP was not opposed to the grant of bail to the accused persons, the DPP applied that the court do have certain conditions appended to the terms of bail. The conditions that the DPP proposed are: 1, that the first accused, who is the governor of Kiambu County, be banned from going back to the office pending the determination of this criminal case. 2, accused persons to deposit their travel documents with the court. 3, all the accused persons not to contact witnesses either directly or indirectly, and or not in any way tamper with the exhibits. Accused persons not to access the offices. I presume this is targeted at specific accused persons who are the employees of the county government of Kiambu. Certainly, therefore, the context in this application is defined by two main issues. That is, that this court has to decide. That is, 1, whether the conditions proposed by the prosecution are legally permissible, and if so, whether the same should be imposed. 2, the amount that this court should set as security for release of the accused person on bail. Out of the conditions suggested by the prosecution, none generated much argument than the one that seeks to bar the first accused, who is the governor of Kiambu County, from accessing his office pending determination of these charges against him. Professor Tom Ojenda, referring to the case, to the High Court case and corruption criminal revision number 13 of 2018, Mohammed Zwazuri versus Republic, and further anchoring his submissions on Article 182 of the Constitution and Section 62(6) of Anti-Corruption and Economic Crimes Act, submitted that imposing a condition that would effectively lock out a sitting governor from office is not constitutionally and statutorily feasible, since constitutional office holders are insulated from removal from office otherwise than by a process laid down by the Constitution. Commenting on the recent decision of Justice Mumbi Ngugi in Criminal Revision number 25 of 2019, a case that involves the current governor of Samburu County, Moses Kasaine Renokural versus DPP, where the judge upheld a lower court decision barring the governor who is facing corruption charges from going back to the office pending the trial. Professor Tom Ojeda submitting that this court is enjoined to interpret and apply the Constitution. Professor Ojeda pointed out that Article 10 of the Constitution represents an embodiment of constitutional principles, which, when considered alongside express provisions of the Constitution, the normative provisions must be applied, such as upholding the presumption on right to bail and innocence. He further argued that even when a court finds a section of law to be invalid, this does not take effect until Parliament repeals it, citing the decision of Justice Makau in petition number 56 of 2016, James Gasheru Kariuki, and 19 others versus County Government of Mombasa. Concerning Chapter 6 of the Constitution, Professor Ojeda referred the court to the decision of the Court of Appeal in Civil Appeal number 290 of 2012, Momo Mateng versus Trust and Society of Human Rights Alliance and 5 others, where the Court of Appeal opined that although Chapter 6 was well-meaning in that it expressed the aspiration of the public to clean up our politics and governance structures, it was nevertheless necessary to ensure that the cases seeking removal or review of appointment on grounds questioning the integrity of the office holder, the same should be based on conclusive proof of such allegations. Counsel further referred to the petition number 552 of 2012, International Center for Policy and Conflict and 5 others versus the Attorney General and 4 others, which was a dispute in which the third and fourth respondents were facing serious charges before the ICC, yet they were allowed to vie for political office on the ground that they are presumed innocent until the contrary is proved. Professor Ongenda submitted that locking out the governor by preventing him from accessing office was akin to ending his term prematurely. He contended that a deputy governor can only act on delegated functions assigned by the governor, and thus without the governor there will be a lacuna. On the amount to be set as security for bail or bond, he suggested various sums which he said should apply with respect to each accused and of which the court took note of. Mr. Swaka emphasized that the fourth and fifth accused are husband and wife and have school-going children, and that the fifth accused takes care of them. Additionally, that the fifth accused is asthmatic and also diabetic, hence her health would suffer immensely unless she gained her liberty and continues with the treatment. It was also submitted that they had fully cooperated with the investigators. Equally, counsel suggested amounts that he considered reasonable to be set as bail in respect of his clients. For the 6th, 7th, 9th, and 10th accused, advocate on record Mr. Biu Kamau urged the court to consider that the only phase 1 count 5, which relates to an alleged omission, insisting that they are not seen to have received or transacted with any cash in respect of the alleged offense. Mr. Muteti, appearing for the DPP, defended the DPP's position in seeking to impose terms restricting the first accused, just like others charged with him, from going back to the office, asserting that doing so would be upholding the constitutional principle of equality before the law, Article 27. He termed the High Court decision in Zwazuri case as a decision per incuriam, inviting the court to take judicial notice of the fact that the nature of these changes would naturally require officers from Kiambu County to be called as witnesses, and it could thus be prejudicial to allow the first accused to go back to the office and continue superintending over them in the hope that justice will not be compromised. He observed that the danger against such witnesses testifying against their bosses was actually real. He was of the view that if the people of Samburu County could go on without their governor, following the decision of Justice Mumbi Ngugi, then equally the people of Kiambu could do so without him, downplaying the suggestion by the defense that there would be a serious lacuna. He urged the court to be guided by the fact that there is a deputy governor who can take over the operations of the county. Mr. Monda urged the court to look beyond the interests of an individual governor and consider the wider public interest, as was amplified by the decision of Justice Mumbi Ngugi. In a rejoinder, Mr. Nelson Avi opposed the prosecution's submission for accused persons to deposit their travel documents, observing that this fact is not founded on any fact, since no affidavit had been filed to demonstrate that the accused are a flight risk. He further submitted that, as a governor, the first accused cannot travel outside the country without the sanction of the national government. Mr. Avi submitted that restricting a governor from carrying out his functions amount to a constructive removal against a constitutional mechanism that is provided for his removal. The first issue that I will need to determine is whether restricting the first accused from returning to the office pending the hearing and determination of this case is a violation of the law. The power of this court to grant board or bail is provided for under Article 49(1)(h) of the Constitution. The article stipulates as follows: an arrested person has a right to be released on board or bail on reasonable conditions pending a charge or trial, unless there are compelling reasons not to be released. The essence of this court in reproducing this article is to consider what is contemplated by the phrase reasonable conditions. Under this article, which upholds the accused's right to bail, the court is empowered to impose conditions so long as it considers them necessary to ensure that the interests of justice are not compromised. If, therefore, a constitutional office holder is charged with a criminal offense and the court is of the view that a condition that limits access to his office should be imposed, would it be a violation of the Constitution? In my view, since the Constitution has given the court the power to impose conditions on granting of bail, it would not be a violation of the law unless, of course, it can be shown that in so doing, the court is unreasonable or has taken into account unreasonable considerations. If limiting or restricting a constitutional office holder from going back to the office can be termed as a constructive removal from office, then it would mean that the court cannot apply Article 49(1)(h) fully in cases of constitutional office holders facing charges before it, even when it considers that circumstances warrant such an imposition. I don't think Article 49(1)(h) intended that certain category of accused persons get preferential treatment when considering the conditions that the court can impose in the interest of justice. I further do not agree that limiting the governor's access to office is an affront to the Constitution, principle of presumption of innocence, for if it were to be the case, then denying an accused bail or bond would be tantamount to condemning them to finding them guilty. Yet, there are many people in remand who have been denied bond and they continue attending court for the trial of their cases. Imposing conditions that guarantee integrity and credibility of the trial cannot be an illegality. In the present case, the court was urged to take judicial notice of the fact that charges accused persons are facing relate to activities that took place within their offices. Consequently, it is logical to expect that witnesses who will testify are people who work in the said county government, where the first accused owns the highest executive office, that is the office of the county governor, where the executive authority is vested. Officers working in the county are at his beck and call. To ensure the administration of justice is not compromised, it is necessary to guard against the risk of possible prejudice in the criminal justice process by imposing appropriate conditions. In my view, restricting access to the office is a reasonable condition under Article 49(1)(h) of the Constitution in the circumstances of this case. I concur with the remarks of Justice Mumbi Ngugi in ACC 25 of 2019 when she rhetorically questioned, and I quote, "How effective will prosecution of such state officers be when their subordinates, who are likely to be witnesses, are under the direct control of indicted officer? Can the issue of Section 62(6) of ASECA, on the issue of Section 62(6) of the Anti-Corruption and Economic Crimes, I would say that following the decision of the learned judge in Criminal Revelation number 25 of 2019, Moses Kasaine and Kolar versus the DPP, the said section has now been rendered nugatory. The judge found in no uncertain terms that the said section offends the principle of equality before the law and Article 27 and further, and if the Constitution and further violates the Constitution, Article 10 on integrity, hence this court cannot therefore be urged to rely on it. Indeed, it must be underscored that this has always been the position of this court, and even in the Zwazuri case, that is what this court had delicately opined. The submission made by Professor Onjenda that even where the court declares a law to be invalid, it does not become so unless repealed by Parliament is, in my view, misleading. The learned professor referred the court to petition number 56 of 2016, James Gashero Karaoke and 19 others versus the county government of Mombasa to buttress that position. However, my reading of the same authority revealed that what was in issue in that case was not an issue of a section of law or law that was unconstitutional. Rather, what was in issue in that authority were two statutes which were contradictory to each other, and the court was being invited to order the repeal of one while maintaining the other. This is what the court said it could not do. It could not be invited to do, and held as follows. There is nowhere in the Constitution or in the Act where the High Court is empowered to repeal or order the repeal of statutes that are considered illegal or contradictory. On the contrary, the High Court has expressed power to interpret the Constitution, and in so doing can declare any law that is inconsistent with the Constitution void to the extent of the inconsistency, and Article 2(4) of the Constitution. In a considered decision, Justice Mumbi Ngugi found the provisions of Article 66(2) of Anti-Corruption and Economic Crimes Act are contrary to the Constitution requirements of integrity in governance, are against national values and principles of governance, principles of leadership and integrity in Chapter 6, and undermines the prosecution of officers in the possession of the applicant in that case. Indeed, she found the same provisions entrench corruption and impunity in the land. This is a decision, unlike Swazuri decision, unlike the Swazuri decision of Justice Ongundi, that delve deeper into considering the entire provisions of Section 62 of Anti-Corruption and Economic Crimes Act and weighed them against the Constitution. I find Justice Mumbi Ngugi's decision more persuasive and authoritative in that regard, and thus considered it as binding on the decision of this court. As for the other cases relied on by Professor Tom Onjenda on issues of integrity, I found them to be more general in their approach, as opposed to the more specific decision of Justice Mumbi Ngugi, which addresses the relevant provisions of the Act on which charges against the accused persons are founded. As for the submission that the governor's absence will orchestrate a lacuna, that too is addressed by Justice Ngugi, where she considered Section 32, subsection 2 of the County Government Act, in which she observes that the governor, if the governor is unable to act, his functions can be performed by the deputy governor. Barring the first accused from going back to the office, therefore, does not violate the Constitution or amount to removal. It is intended to ensure the integrity and credibility of the trial and to ensure that public interest is safeguarded. Indeed, the judge in Anti-Corruption Case number 25 of 2019 captured this concern more aptly when she remarked, and I quote, "He is charged with basically enriching himself at the expense of the people who elected him and who he is expected to serve. Would it serve the public interest for him to go back to the office and preside over finances of the county that he has been charged with embezzling from? What message does he send to the citizen of their leader when their leader, if their leaders are charged with serious corruption offenses and are in office the following day overseeing the affairs of the institution?" End of quote. Consequently, this court will grant bail to accused persons and impose the following conditions. The first accused shall not access his office until this criminal case is heard and determined. Equally, accused persons who are employees of the county government will not access their offices during the pendency of this criminal case. The rest of the accused persons are also barred from setting foot in Kiambu County offices pending this trial. All accused persons will deposit their travel documents with the court to minimize the risk of accused traveling out of this court's jurisdiction without the leave of the court. For those without passports, a confirmation of the fact must be given by the Department of Immigration. They must not contact witnesses or in any way interfere with exhibits or any evidence. Concerning the amount to be sent as security for bail or board, the court has categorized the accused persons into three groups as follows. In so doing, the court has considered their counsel submissions, the number of counts that each accused face, the personal circumstances of the accused, including their health, and this was in respect of the fifth accused, the amounts involved, the fact that some of the accused persons are charged as a family, husband and wife, and further, additional information provided by counsel in their submissions. In the first category, I place the first accused and the fourth accused. The fifth accused also belongs here, but the court has considered a lawyer's submissions of ill health and the fact that she is a spouse of the fourth accused, and purely on humanitarian grounds, discretionarily moved her to the second category. As for the first and the fourth accused, therefore, each shall be released on depositing a cash bail of Kenya shillings 15 million, in the alternative a bond of Kenya shillings 30 million plus a surety of like amount. In the second category, the court places the court places the second accused and the fifth accused, who shall pay a cash bail of Kenya shillings 4 million each, in the alternative a bond of Kenya shillings 10,000 plus a surety of like amount. As for accused 6, 7, 8, 9, and 10, the civil servants who sat in the tender, who are arranged to have sat. So who are arranged to have sat in the tender evaluation committee and face County 5 alone, they shall be released on depositing cash bill of Kenya shillings 1 million each, in the alternative a bond of Kenya shillings 3 million plus a surety to like amount. Yes.
So the second and fifth accused to pay 10,000 Kenya shillings for clarity purposes?
10,000.
What did you say?
I said for the second accused. In the second category, the court places the second accused and the fifth accused, who shall pay a cash bail of Kenya shillings 4 million each. In the alternative, a bond of Kenya shillings 10 million plus a surety to like amount.
4 million.
Yes.
What category did you put the third accused?
We have a third accused.
Yes, we have a third accused.
I think
Your
this.
Honor prefers goes happy with us.
Unfortunately, I should be able to check where he belongs, and I place him accordingly.
The civil servants category.
No. Civil servants are in category. The ones in. Those are the ones in count number 5. That accused is in which count? Luka Mwangi, Wahinya.
Yes,
So this one is in category 1.
For clarity, category 1 you said it was 15 million Kenya shillings?
Yes. This one is in category 1. I have looked at the amount of charge, the amount arranged to have been lost. So it will be in category 1. So it is first, second, and third will be in category 1.
When you have one application together with documents.
Yes. Sorry, was it second accused? I said category 1 is first and fourth. Yeah? Okay, let me check. You know, I was doing this thing in a hurry, so you'll excuse me, please. Yes. I want to place them appropriately so that I also don't do an injustice here. So first, in category 1, we will have the first, third, and the fourth. Yes.
Yes, Your Honor, we have an application to make.
Just a minute, please, Counsel.
Your Honor, may we apply that the court avails certified
Okay, so
copies of
sorry,
proceedings?
Counsel. As for the the first category, we will have first accused, third accused, and fourth accused.
First, third, and fourth.
Yeah, first, third, and fourth. Then the second category is the second accused and fifth accused, who are spouses of some of these people.
Yes, Your Honor, just for purposes of record, we wish to apply for
Yes.
certified proceedings, type proceedings. We shall be applying for revision of your decision.
A second one.
So that we can have another decision.
Okay.
Before another hearing.
All right.
Yes. But we thank you very much, Your Honor, for
So certified copies of the proceedings to be supplied.
proceedings, and we shall pay cost, we shall pay whatever it requires us. And the ruling, proceedings and the ruling. And if the ruling is available, we could even have it.
I was not able to type the ruling.
It can be shared if it's available.
I was not able to type it because of the limitation of time, but I'm sure this one can be done very fast.
If you can you have that today, because we need to.
Yes, I will ask them to do it,
Yes, to
so
do it
that
quick, so that
you
we-
can collect it by the end of the day.
File can be ready.
So we can take a mention date to confirm compliance.
Tomorrow?
Compliance.
Yes, we can be here. They can type together. We come tomorrow, and then we can. It's a short.
No, not for collection of the proceedings.
No.
For compliance, you know, you have to supply them with the documents, or you have already done it.
Yeah, they haven't know. But you're not, on the second day, we have not been supplied with any document. We do not even know. We don't even have the full menu of the witnesses yet. The witness statements have not been supplied. And I believe those would then be, they would need to tell us when they supplied the witness statements and when they would supply other documents that are necessary for the trial, so that when we take a pre-trial date, we have those documents. We have none of the documents that we require for this trial.
Mr. Mutete, how much time will you require to supply those
I'm
documents?
advised by the investigators that require about 3 weeks because of the number of the accused persons.
3 weeks.
So that if you want to come back and tell you that.
No, you honor 3 weeks, such an inordinate long period of time. The prosecution indicated that they were ready for a trial. If they were ready, we do not require 3 weeks. I think at most give them a week.
Your Honor, maybe if I could be fair to my friend, fine, if they are ready to receive soft copies, we can shorten the period so that we can
No, we can't.
copies themselves.
No.
And also make them understand.
Can we, Mr. Mutete, you know this. When an accused person is brought to court, Your Honor,
Yes.
it is only fair, and we have been through this before your brother, Mr. Ogoti.
Yes.
When the prosecution should present an accused person to court when they are ready for trial. So that once a plea is taken, Mr. Mutete, we should kick off with the trial. Where are those statements? They do not have those statements and cannot purport to supply them in soft copy. Let us have a proper bundle of documents as contemplated by the law, exchanged, physically exchanged, not through some computer device. Let them get them ready. Your Honor, if they could try, now that he says that they have incapacity, we understand. If they could try and even do 14 days, they're saying 21 days. We can mention 14 days if they're able to get all the documents, then we can come back. I thought that they were ready. That was my impression, that they were ready.
Your Honor, for the record, we are ready. Let my line friends stop insinuating that we are not ready. If he has a problem with electronic documents, then that is his problem. And we will more than willing.
Your Honor, there is something which may not wait even a day.
Yes.
You have ordered that the accused persons should not contact any witness. We do not have a list of witnesses. And these people will be in trouble when they communicate with people they don't know. Then you are told here, Your Honor, that they communicated with a witness. Maybe they talk to a witness, they were trying to influence a witness. So that may not even wait a day. Let us have the list of witnesses. We don't have it. They don't know who is a witness in this case. And Your Honor, that is an order from this court.
Let me do
bring us
this.
into problems.
I'll be away from the 12th up to around 23rd of August. So I'm coming back on 26th. So why don't we mention the matter on 26th?
26.
Yes.
It's okay, we can.
The court will be away. I'll
Because of
be
the
away
court,
for
we can
between
come back.
12th to 23rd of August. So
At
we
least you
can,
agree on that one, Mr. Mutete.
yes, we can mention the matter on 26th
26th of when, Your Honor?
of August.
maybe before you pen off,
Yes.
in our application in regard to the fourth
Yeah.
and fifth accused persons, we relied on some documents that were original, belonging to children and to their.
These documents, I carried them home. If I lost them, I don't know.
Unless their children migrate into your home, because now they have passport.
I'll give them to my court assistant to sort out.
Maybe with your leave, we can approach her so as.
Yes, but you will have to leave us with the copies.
Thank you.
Now that you have relied on them.
Thank you so much.
Lastly, just so that we not again caught up in this problem of exchange of documents.
Yes.
If Malaya friends could give us their addresses, because the experience we have, some of them have been important. We can barely trace them until the day you can just mention. So we have to be kind enough to do so.
I think that is a reasonable proposal. So Pretty, you can pass a full stamp to them so that they can indicate their addresses. When the bundles are ready, you can be called.
We will do that, but you want
Yes.
may I make a further application?
Yes.
In view of the fact that a revision under Section 362 does not require the procedure of typing, the file itself can be sent upstairs to the judge without process. Particularly, even barring your order on visiting the county, which now goes beyond the Mumigubi decision. That's for, because you have not said whether you can visit with anyone.
No.
But you agree, Mumigudi had said you can visit with the ESCC. But you said it doesn't go. That's fine. Now for the sums, at least let us deal with the sums. I apply that you allow us, that you refer the original file to the judge in the anti-corruption court for purposes of making an application under Section 362 of the CPC. We pray that the matter be mentioned before the High Court judge today at 2:30, even as we pass through the other proceedings that you have indicated. I believe this is the most prudent way to proceed.
I'm finding it a bit difficult to make an order in the lower court files.
No, normally it's through a letter. We do the letter.
Yes, you just do the letter.
Today, we do the letter in the next 1 hour.
I think the best
Yes.
thing is to do the letter to the deputy registrar,
Yes.
requesting for the file, and
Yes.
then she will write to ask us to take the file to the High
To
Court.
quickly avail it.
Yeah, that one will be done. That is a procedure. Because now I cannot direct in this file that the file be placed before the
Yeah,
judge.
but at least you understand the.
Yes, I understand.
We want to set up the court again as the High Court.
No. You know what you're doing.
Okay, so we will mention this matter on 26th of August. So, mention on 26th August 2019 to confirm that the prosecution has availed all the material it intends to rely on in the prosecution of this case.
I pray for your last indulgence.
Yes.
I would pray that the court directs
Yes.
a period within which the first accused person can collect his personal belongings from the office, pending all these processes.
Okay, make an application. I will deal with it.
A form application.
Yes, just make a form
No,
application.
we'll do that.
Yes.
We'll do that. I thank you so much. Thank you so much.
So in the meantime, I wish you all the best,
Thank you so
including
much.
challenging this decision.
We'll come back.